We'll be taking a look at the judiciary and then a little bit about the fight against corruption. But let's give you this report so that you just have an idea of what we want to talk about today.
It was a motion that received the support of most of the senators present. It focused on the refusal of the Chief Justice of Nigeria to swear in Justice Ifeoma Jombo-Ofor as a justice of the Court of Appeal, following petitions that she's not from Abia State, in spite of her marriage to her husband, who is an indigene of the state. It was an action the Senate was displeased with.
It's whether a woman of Nigerian origin, married to a Nigerian, resident in Nigeria, can be a judge of the Court of Appeal in Nigeria.
We are being told that an Igbo woman cannot have opportunities in another part of Igbo land. In the same country where years ago an Igbo man could be Chief Justice of another state in the northern part of this country. Are we progressing or we are retrogressing?
A senator attempted to make a defense.
There was petition, and in fact some people were physically there to protest the swearing in of the said judge. So it was kind of suspension pending the petition. That was what actually happened.
The move was not appreciated. The Senate President said the act also threatened the plight of married professional women.
But more importantly, the sanctity of marriage will be destroyed by this act if we allow it to go. And I believe that we want to encourage professional women to maintain their profession and keep their marriage also.
The motion was adopted unanimously. The Senate also directed all government agencies to take note that a married woman can lay claim to both her state of origin and that of her husband. The Senate spokesman said the Senate believes this resolution will be complied with.
And I don't think the Senate is inclined to draw lines, and we do not also feel that the cooperation that we have enjoyed with the other arm of government, the judiciary, will in any way be tested by this.
The days ahead will show if the judiciary will comply with this resolution. Lanre Lasese, Channels Television News.
Well, that did happen some time ago, so ever since that report, a lot has happened. Well, we'll try and situate it as we do go on. Well, we're joined now by Mr. Manuel Moran, who is a legal practitioner. Thank you for coming on this morning.
Thank you very much.
Well, looking at that report alone, of course, as a lawyer, for those who may be watching, there's so many things that perhaps needs to be talked about which may not have been captured in that short report because of the time and the duration of it. But from your perspective, give us a background. What really is going on there?
Well, the problem we have here is a problem of interpreting the law wrongly. Because I think that the advisors of CJN should have looked at Section 42 of our Constitution, which doesn't allow any discrimination whatsoever. If there's any discrimination against you, you can go and enforce the right. Your fundamental rights, and it's part of the enshrined position of our Constitution that the rights are inalienable. No, you cannot take it away from anybody. So you cannot discriminate against somebody by place of birth. That was the mistake the advisors of the CJN made. But good enough, the NJC has put its house in order, and the CJN has agreed to swear in the lady. But the good part of it is that people are now aware that it has brought out this discrimination against women, because it happened against Mrs. Justice Bolaige when she was to be CJN of Oyo State. They said she was not from Osun State. They said she was married, she was from Oyo State and not from Osun State, so she couldn't have been the chief judge of that state. That's why she went to the Court of Appeal. And good enough, now everybody is saying this, that it is your competence is not from where, it doesn't matter where you're from.
Yeah, but could that be the sole reason? Because, I mean, that those who just can't come to terms, if that's true, that CJN would deliberately want to discriminate against anybody, having known the law herself.
Yes, you see, we have to realize one thing. People in office have advisors. And they said it was based on a petition from some persons. Because I wonder why, if a state government has nominated somebody to represent its state, and for what reason or the other, that the woman was not born from that state, then the woman would be discriminated against when our own constitution allows for any African that his child is born in Nigeria, is automatically a person is a Nigerian.
Yeah, but
Our constitution is Pan-African. Why should it not be Pan-Nigerian? Do you understand? It's so silly if we interpret it that way.
Okay. Explain this to us then. The guidelines under the Federal Character Commission Act, I think they refer to it as, guiding principles and formula for the distribution of all cadres of posts. And they say it was developed in pursuance of Federal Character Commission Establishment Act Decree 1996, number 34. And on that part 2, clause 2, which provides, quote, a married woman shall continue to lay claim to her state of origin for the purpose of implementation of the federal character.
Yes, you see, that is why the problem I have with our National Assembly. We have members of the National Assembly that go there and drink tea and collect so much money for doing nothing. How many laws have they reviewed? This is the 1976 Act. What have they been doing? The world has changed. We have a policy today that you must have 30% of persons in government. Women, at least 30% of women must be given positions in government. How do you do that when most people above 20 or 25, in the north above 20 are married, most women, and above 25, 30 in Nigeria, in the south they are married? What do you do about those large chunk of people? So the National Assembly should be more proactive in its legislation. You don't be waiting for crises like this. Look at what they did. They passed the resolution. What's the resolution? Why did they not go ahead to find a process of amending that act immediately so that it will not come up again?
But, people have been asking this question. This particular petition, which the CJN said she received from people of Abia State, kicking against her being from that particular state, should that have happened in the first place? They say in law sometimes there are some petitions that you can actually disregard if you know that, it lacks substance.
Yes, I think the CJN also did not do too well there. Because when you have nominations of this nature, I think the CJN should have called the NJC. Because the NJC would have approved before the nomination comes. You get, because if you look at what is happening in Osun State, the governor wants a particular person, sent a list, and I think the same thing happened in Adamawa State, and the agency rejected, because you see, the law is that you shall make a recommendation to the NJC, which will now approve and give you back to take to your State House of Assembly or to the National Assembly. So for that process to have been done, NJC should have sat on that petition also, to review it and say, look, is it right? Is it proper? Is this? Because, yes, the CJN is the head of all institutions by authority, not the person of Honorable Justice Aloma. But the fact is that office is an office imbued with so much power and authority. So I would have thought that before coming up, we would have avoided this unnecessary controversy by calling the NJC to an emergency like they've done now and say, look, this is the petition I got. What do we do before the swearing in?